the words litigation and arbitration. So for our audience,
irrespective of you spend millions even with your lawyer, you'll only be maximum up to the mark of 2,000 dirhams.
of course, with $23 million, why not?
Happening in Ajman, they gave the jurisdiction to Oman Arbitration Center. When you say agreement, I would say first and the foremost thing before entering into any agreement.
So your clients are majorly the developers themselves, the customer or the middle party contractor.
Let me tell you a small secret we have.
Abel, to start with, since you have expertise in investment and real estate, so I would like to understand what is the common reason for the construction and real estate disputes in UAE.
So for the construction phase, if you take up for construction, the most common issue that arises when it comes to a litigation, or rather the causative factor, is often delay in completion, because there will be an ideal stipulated completion date and that phase is not completed, or rather it is not being achieved by one of the subcontractors, for which sake the main contractor also falls default to the end client. So delay is one causative factor. Second, of course, defective construction. So defective construction is having major different ambits to it in terms of the upper, because usually here in construction there is something known as FIDIC agreements, based on which most of the construction happens. And for that, there will be an engineering consultant being appointed by the end client who approves the work, who certified the work that being is good. So often, sometimes his approval might contradict with the actual scenario, because it might be actually be defective. Then there are provisions of defective criminal liabilities which comes up. That means after a unit or a structure is being erected, it is built up, still there can be a liability factor that can fall upon the main contractor or the developer for 10 years post-construction. If it is a material issue with the whole structure, that means, say, in one of the instances, the basement happened to collapse. It was already an occupied building by many of the investors, and they were actually doubtful whether to go against the AMC company, that is the maintenance company, building management company. And it was not actually a case against the building management company. It was actually something to be fought against the developer and rather the main contractor. So these are the common kind of issues that arises in construction. Coming on to real estate are, as you know, it's like off-plan sale that is happening and the secondary sale. So for off-plan sale, you can very well see, if you look around, that each week we have a new launch happening for a new project when it comes to off-plan sale.
True.
So again, there also the delay in completion is a major issue, because many of them get attracted just for the payment factor involved. They're not about what is the reputation of the developer, how big a paraphernalia or how big an effective team do they have to execute this project within the stipulated time frame. So often these things invite troubles in when it comes to the completion of the project, when it comes to off-plan sales. Secondary sales, if this transaction is not going through within the definitive time period, there are often provisions for liquidated damages. That means the compensation part, if that deal doesn't happen, will be often be very well laid out. And these damages are also one other causative factor when it comes to real estate transaction. Extended time, when you say real estate, it also falls within the ambit of rentals also. So rentals is common. I mean, non-payment or destruction of the leased out unit or subletting the unit. So these are all common factors. Then it comes to the rental element. When you say real estate, it's a very broad term actually.
Yeah.
So yeah, these are all the very common causative elements, or rather the causation of disputes.
So your clients are majorly the developers themselves, or it is the end user, the customer, or the middle party contractor?
Okay, so let me tell you a small secret. We have sued almost all the renowned developers up here. So because we mostly have end clients, end users, or end unit owners, or rather villa owners or flat owners, whatever. Most of them, we have clientele on that side. In fact, our firm actually got a momentum on that front, because post-COVID, we did a batch matter against one particular project, against one particular developer.
Okay.
Around 52 plus investors, villa owner investors, against that developer because they did a major default as to the change in the unit plan, which was done without the consent of the investor. That actually gained us a good momentum. So likewise, we do have a good lot of clients on that front. And of course, when it comes to construction, sometimes we represent the end clients who gives a plot for the main contractor to build villa. Sometimes we represent the main contractor themselves. Sometimes it's a subcontractor. And sometimes, which happens not in all the projects, but because it happens only in very big, tight, big volume projects, we represent the funders to a project. So there are construction projects which are being funded out by external entities or some other bodies, which they actually fund the project. And we represent those fund providers.
You had used a couple of terms while you were explaining about the common reasons for this disputes, and you used the words litigation and arbitration. So, for our audience, can you please explain the difference between these two terms?
Okay, so litigation means it's just like going to the mainland court. You approach the court saying that there is a breach. The opposite party has committed this default. They have breached the terms of this contract that I want you to adjudicate, rather decide over it and get it fixed for me. That is called litigation. So when it comes to litigation, I should say something very interesting. Of course, that is very much known, but still the UAE has a peculiarity which has got three jurisdictions to be said. One is the mainland court, which is by the government themselves. Then DIFC, which is a free zone having their own court with the English rules or place, English laws or place. Then comes the ADGM court, again another jurisdiction, another free zone with their own court. So ADGM and DIFC is the only two free zones in UAE which is having their own courts, their own internal courts, and they do have a separate court system, rule procedure, and their own laws as such specifically. Of course, their own laws are there for other free zones also, but their own code procedural rules are there for these two free zones. I mean, free zone codes, AFC code and ADGM code. So we have a wonderful blend over here in UAE that way around, if you look at it, which is not there in many other jurisdictions, at least to my limited knowledge. Because mainland court, as I said earlier, it's a civil law jurisdiction. The AFC and ADGM, it's a common law jurisdiction where you refer to the precedent court rules and everything, and you can go and have an oral argument also. In DFC courts, I'm speaking.
Okay.
Litigation. And now coming on to arbitration. Arbitration is actually a version of something called as ADR, alternative dispute resolution. So arbitration is like we decide that if in case a dispute arises, that will be adjudicated by party X. He will be a neutral party to us, both of us, and having no favoritism to either one of us. And we will fix him to adjudicate over the dispute. And after hearing both of our versions to the story with all the evidences, written evidences, oral arguments, and everything, he will pass a final award, and that award will be ratified by the court and it will be executed.
Okay, so you are not going directly to the court here. There is a third party involved.
So there are two types of arbitration: ad hoc arbitration, wherein you can appoint any random person as the judge or rather the arbitrator typically adjudicate. And then there is a body, there are something called as institutional arbitrations, to which we have bodies like DIAC,
Okay.
Arbitration Center. So DIAC is one body, and then there is ICC. There are a couple of institutional arbitrations, arbitrational bodies which are there in UAE. They typically adjudicate over the disputes, or rather, they decide over the disputes.
Based on your experience, what would be the an ideal method of dispute resolution? You prefer litigation or arbitration? How is it decided?
See, it's I would say if on my personal, very personal note, I always try to recommend the jurisdiction or the method of adjudication depending upon the contract value, I would say. Because if the suppose if the contract value is something less than 1 million, say it is always preferably better to go for the mainland courts, because mainland courts you get sorted, as I said, in 4 to 6 months span.
Yeah.
you have a fast remedy. Then there the adjudication process will be more, into the minute details and everything. They will delve by appointment of an expert. So it is faster. Whereas if it is a very stateful dispute, something running, let's say minimum bar of 1 million or a 2 million dispute that is happening, it's always better you appoint in to have an arbitrator, rather you have an arbitration clause within the contract, because there you will require more detailed trial, more detailed assessment of the fact and the arguments and everything. And it would be, it would be sometimes be very painstaking on one of the parties to take the blow of being liable. So rather the adjudication should be, absolutely be meritful in all respects. So I would suggest go for an arbitration. Plus arbitration also do have one major perk, that if you're going for an arbitration, every single penny that you shell out to a lawyer or the notarization or you name it, whatever, every single penny what you shell out, that is recoverable entirely in an arbitration proceeding. Whereas if it is a mainland court litigation in UAE, you will be allowed a maximum attorney fee of only 2,000 dirhams. That means, irrespective of you spend millions even with your lawyer, you'll only be maximum up to the mark of 2,000 dirhams. UAE code generally by the code decision. So that is one difference. Secondly, say suppose I had one bad instance where we had a very small stake dispute happening around close to 500,000, and that was given the close with arbitration. I made the application to the concerned arbitration body. I initiated the arbitration, and so to initiate, we need to file something called as RFA, request for arbitration, which is the registration of 5,000 dirhams. So once that was being done, it took almost 7 months to constitute the arbitration tribunal. That means to find a arbitrator, or rather in simple terms, to find a judge for you. Interesting reason, because it was a very small stake amount. Rather, the arbitrators also will be least interested, because the matter of dispute is only for a very small claim. Okay. So I would say typically to decide on you whether to go for a mainland court or to go for an arbitration, I always recommend decide it according to what is your contract value. Okay. So contract value plays a crucial role. Second thing, of course, where are the parties based? Because, when you say arbitration, and my client can be in Dubai and the opposite guy can be elsewhere on the other part of the globe. Yeah. So jurisdiction, or rather where the parties are having their line of business or where they are based, is always the one factor, because that has a crucial thing to play when it comes to enforceability. Whereas in litigation, again, in some jurisdictions, if you get a judgment from UAE court, it may not be enforceable in the other jurisdiction. Yeah. Whole of your attempt to litigate becomes futile, nothing much. Very recently only, couple of years back only, the Indian judgments were recognized, ratified, and made enforceable here. Okay. Had a bilateral treaty quite some years back itself, but it was not actually happening. Like, you had to file a case against me in Dubai, you can get a judgment. But then if I flew to India, you'll have to probably file a separate case back in India. This was the scenario quite some years back. Okay. You can get a judgment over here and execute it in India as well. Okay. That's a good news. That is not the case with all the countries. It can vary depending upon, what I said, it depends upon what is the treaty between the two nations. See, most of the courts, they don't allow too much for attorney fees, but in addition to the principal claim, whatever you're asking, they will allow a 5% interest. Okay. 5% interest is exciting to you? That's exciting. It's not at all exciting. Exciting to you, that's it. We can't help over it. So that's what I'm saying by practice, but by law, it is like up to 9% is can be allowed as interest. Is it that now there are all online hearings and trials happening in Dubai? That facility is available in all the three jurisdictions that you mentioned, all the three courts? Online hearing? Yes. Online hearing, yes, but see, ideally, whenever we get into the picture, it's always on online session that is happening. And okay. For Dubai DFC courts and all, you can have an oral hearing with the judge. So they have this facility.
in all the courts?
Not all the courts. I mean, I'm saying for mainland courts, it's always mainly online submissions do happen.
Okay, okay. I mean, they prefer that.
And it's very short, unlike what you expect if you are comparing yourself with what is happening back in India or any other common law. There are very small hearing sessions that happen.
Also, as per my knowledge, if you are having your trial in Dubai court, especially, it's all in Arabic, right? You have to have someone Arabic speaking representing you, right? And even the document submission is all in Arabic.
The entire proceeding will be in Arabic in mainland courts, not only in Dubai, in all the Emirates.
Okay, okay. And what about the DIFC and EDGM there? There they prefer it.
DIFC is mostly preferred by companies based in DIFC or some who are very keen, they are comfortable with that jurisdiction.
Okay.
Reasons ideally why most people do prefer for DIFC and ADGM courts.
What is the average time span and the cost involved in both the processes?
Average time span for litigation, as I said, in mainland court, it runs up to 4 to 6 months, civil or commercial litigation. But regarding the cost, if you ask me, there is a court fee, which is capped at 40,000 or rather 5% of the claim amount. And then post that, there is an execution fee also that will be payable. And
Okay.
that is just for mainland court litigation. Whereas if it comes to arbitration, time span, I literally cannot lay out because ideally, it is supposed to finish within a span of 6 months, but it is extendable for another 6 months.
So maybe it can stretch up to a year.
Yeah, up to an year, but it's even spills over because in recently when we did a case, we were contesting against the opposite party and they were actually suing the end client and they took up that reason and say that the arbitration proceedings should be put on hold. And for that sake, we fought like anything else to lift up that hold factor. But unfortunately, it was a back-to-back agreement. I mean, it was only we were giving out best shots, but it was clearly written that it was a back-to-back agreement. But still, we tried. The proceedings were on hold, unfortunately, for us, and it went on for more than a year. And then we got something favorable in the mainland court for the respondent. They got something favorable in the mainland court, like expert report was mentioned in their favor. And with that, we tweaked upon and then we resumed the arbitration proceeding. Finally, it came out in our favor. So basically, even though by law it says that you have provisions to hold the proceedings also in between can be for XYZ reason.
Okay. Fine. So coming to the agreement, suppose if we decided to include an arbitration clause, so what are the elements to be taken up for consideration?
So I would say before, when you say agreement, I would say first and the foremost thing before entering into any agreement with anybody is have a proper due diligence done. When I say due diligence, for most of them, it's like financial due diligence. Just as you do financial due diligence, it's equally important to look upon or rather having a clear understanding on what is the legal due diligence as well. Because to tell you on a very interesting storyline, one of my clients, he invested pretty much stakeful amount with one of the renowned developers up here. And basically he was funding that company. He was funding that company in terms of not for the projects. He was generally funding the company.
Okay.
Large sum amount. And at a point of time that really didn't happen. They didn't get to perform their obligations and my client was not getting the payouts. And then he initiated one proceeding, but it didn't work out. And then before coming to us, in fact, he had a big time realization that he was pitched with the brand name of the company and he signed on an agreement which was a sister concern to the company. So the privity of the contract, rather the main agreement based on which we were going to dispute was with a sister concern of the company, which actually never got the funds.
Okay.
The funds were routed to another company. This is a clear example of lack of due diligence.
Yes.
Finally, after doing this whole exercise, we said that if you need to initiate a case, you will have to include all of them in the party area, like the branch company to which you actually gave the funds, the company against with whom you signed upon the agreement, and then the managers. It was like a massive firing. We were firing at all ends, and we used something like lifting of corporate way partly, which became successful, fortunately, and that helped us to get a positive result. So of this was a clear case which shows that there was a clear lack of due diligence. Imagine he was funding millions. So before signing any agreement, I would say legal due diligence, have a clear understanding about it. Second aspect, whenever you sign an agreement, is your exposure to liability. So when you sign any agreement, there will be an exposure of liability where you assess what is the risk element to it. That risk element is like how exposed you are liability, how you can be sued. Something that people tend to overlook, probably in the excitement of, oh yeah, it's such a big deal.
Yeah.
So there you can fine tune it in many a way. One aspect of it is called limiting the liability, limitation of the liability, where you cap the liability. You say that XYZ may happen, but this is going to be the maximum claim you can have against me. That is one fine way to it. Second way is like the warranty clauses, the representations, or rather the assurances that you make while selling or while.
Yes.
These are all very areas. The representations that you make to a party while signing an agreement is very important. So representation and warranties are very important because they are usually being treated as a part of the general conditions, but you can actually be taken for a good ride if you make a wrong representation and if you give a wrong warranty. Yeah. So that is one side. And the last one is, I would say, governing law and jurisdiction, like what law should govern this contract. So I would say these are the elemental things that you should have a clear sense and clear understanding over and above the major terms and conditions, because people are pretty much clear, like how much I will shell out, how much I will get back, and at what point of time I will get back, and to secure that get back, what all I will do. People are usually very clear on this. What is the other side of the coins where I can fall into trouble?
What you are saying is not just limited to like real estate or construction line of business, anywhere, everywhere. Do you see that in coming time, in near future, these cases are going to increase, or there could be a decline in income? Looking at the trends, what do you have to say?
Okay, very interesting question. I should say, see, post the two wars, the Russia-Ukraine war, I would say there are a lot of investments coming into this part of the world. Happy news to many, especially based here. They are parking their funds up here. But now there has been, I would say, the wave is getting back because some, they want to retrieve back their investments, or they want to retrieve back their funds, and they will need to go back. Some are like, okay, I made the investment up here. Let me get a real grip of it. So all these are like, they are getting a lot of traction in terms of investments. They are getting these things, these factors, or probably these kind of mentality, I believe. These are tending people to, or rather mooting people to go for a dispute, litigation or arbitration, because, either they want to get back their funds in spite of some commitments they have made or a contract. They want to retrieve back all of that. Some are like, get real grip of it. So of late, I see a good lot of disputes on partnership and on investments. There is a very fair upscale, I would say. Moving on to real estate, I think now when seeing the number of projects being launched, I really doubt like how far will it say, because it is assumed that around 250 plus developers are there in Dubai alone. And the crowd does know probably hardly few names. But if you look at it, the number of projects which are actually reaching the completion stage are far less. That, of course, is a good reason for construction. The flip side of the coin. Construction is one industry which I believe will never to fall so soon, especially in this part of the world. Because if you look around, you just move around the city, you will see at least in a day, you will be passing at least 3 or 5 construction sites easily. For construction, it's a credit industry. So if I start firing against you, then your next thought is like, let me shift this liability. And what do I do for that? I sue the other guy. Construction is also one such industry. So I think, yes, definitely there will be a scale up in the number of litigation.
So your business is going to flourish. Well, so could just tell me what's the haywire factors, while signing upon an investment agreement or a shareholder agreement?
Okay. So, haywire factor, I would say, see, when you say investments, first question is how do you structure your investment? So if asked, like, I want to invest in some company, what would be the first thought that comes to you?
Would look at the performance of the company, the background, how much money it's making, profitable or no. Of course, numbers is the very first thing. Rest all is secondary.
Okay. Then at least what could be your second thing?
Then I'll check the background for sure. Whatever numbers they are showing, if they are having loans, debts, or anything, these numbers are just fancy or no. That would be the second thing.
Okay.
Yeah.
Both the times you are hanging around the financial element of it, or rather the reputation and the goodwill of the company. This
Mhm.
is really important to decide how you're going to invest as well, especially when you're having a substantial sum. So I'm not speaking about investing into a platform or a trading platform or anything else. You decided to invest with a company. So sometimes you can invest with a company by buying out the shares in the company, partner to the company, taking all the troubles of a partnership, taking all the troubles that the company may face. This is one way to do it. Second way is that you just be an investor. I'm funding you, funding you, funding you, funding you. You do it in whatever way you feel like, but I need clear payouts.
Yeah, most of the people go for this second option actually. They don't want to get into the operations.
Structure that is very important because in some cases, just to fund the companies, they buy out shares in the company, which say is not recommended always because if the company is going to, if something goes adverse, that would not be. But if something goes adverse, his shares or rather his funds are also equally going to be
Affected.
whereas if it is a private investor, that is a lot more different. Secondly, if you are if you are investing with a particular project alone, you have a renowned company and you know that that company is good at XYZ and they are going to take upon a very vast project of this bandwidth and you want to fund that project alone. You're not going to invest with the company. So then the question is how do you fund to that project alone? Some say change, some join ventures, some say let's give it an SPV, a special purpose vehicle, just for the project purpose alone. So the first question is when you say investments, how are you going to invest is very important. Second thing, holder agreements. So the purpose of shareholder agreements apparently here I would say is, it lays out many things which is missing probably in the memorandum of association of a company. Say for an example, back in India, there is memorandum of association and articles of association. So the memorandum of association lays out about the core of the company, like what is the shareholding, what is the exit pattern, where it can be liquidated, blah, 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 blah. And articles of association, it just mentions about the proceduralities or rather the modality in simple terms, like a board resolution need be done. What happens if one of the director or shareholder dies? What happens to the management? So here in this country, you don't have an AOA as such. So to fill up that space, I mean, you call it memorandum of association, memorandum and articles of association by terminology. Ideally, it doesn't cover the full stretch of it.
Okay.
So a shareholder agreement can apparently cover up all these portions. Like both of us are forbidden something happens to me and I was handling the show of the company. Of the company. What happens to the management of the company? That can be laid out in a shareholder agreement. Second thing, if both of us are partners, one fine day, I am the major stakeholder and I decide to quit. I'm done. So probably you might be looking out to buy out the chunk of the company, but I'm not interested to give away with you,
Oh,
getting along with you as a partner in the company.
okay.
So that can affect your interest. So these kind of scenarios can be vastly and be well covered in a shareholder agreement.
So if I may ask a question, does this shareholder agreement supersede the other documents that are there, like MOA or AOA, whatever is designed?
It doesn't supersede. It's actually a complementing factor.
Okay.
I mean, shareholder agreement, the kind of a core purpose is to lay out the exact procedurality or the functioning method of a company on one side of it.
So basically, what I wanted to know was like in case of conflict, this document is very much valid, and on the basis of this, we can fight, sue, whatever.
Very much valid and very much enforceable.
Okay, great.
It is not that it is only a mere piece of paper.
I would like to know if there are any trends of any reforms that the government is coming up or the concerned authorities are coming up with respect to this area to mellow it down.
See, on in terms of disputes, I would say I was recently taking part in the Dubai arbitration gate, which is still on
Mm-hmm.
last day to it. So I was taking part for their opening ceremony, and I was pretty much delighted to see that in Dubai you have legal professionals flying from across the globe coming in, and they're just networking. And what I could sense and what I could understand is that, at least over Asia, many people have started to prefer Dubai International Arbitration. I mean, DIAC as a preferred jurisdiction for disputes. So the main arbitration hub in Asia is Singapore, SIAC, which is very well renowned, established. Also, HKIC, Hong Kong also is not for it. Dubai also has started slowly gathering the momentum in that line, I would say, because there are, as I said, I could see professionals from across the globe, and it was such a huge momentum that was evident over there. That is one side of it. Second thing, I think on the trends, if you ask me, is involvement of AI. That is remarkable, I would say, because in each aspect of it, when concerning to legal industry in general, I would say the efficacy that it provides, even for adjudication. If you look even across the globe, says, for example, in many other jurisdictions, in many other arbitration bodies, they are actively using AI as a method for conducting their procedural things, which is fastening up the method. And I believe Dubai will never be far behind it. We will soon adopt. I think I'm very proud to say that Dubai is always known for its adaptability factor.
Two things I want to know here. One, can anyone from any part of the world, can any lawyer can come and represent their client first? And secondly, can this case be handled somewhere else as well? UAE is having an agreement with that company like India now, you said.
Okay, so first thing, can anyone from across the globe can come and practice? Ideally, the answer is it's like for consultancy, it is doable for consultancy service. It's for attorney, being an attorney. You need a local on board. You need a local lawyer on board for that. And for DFC coach or ADGM, you must be registered with them. You must be a registered practitioner with them.
Is it a very tedious task, or if you are a well versed lawyer in your home country, it's easier to get that registration done?
Tedious task, I don't know how. I mean, it was not tedious for us. I don't know
Okay.
the tedious for the rest. So because you can get to register as an individual practitioner, and as well as a firm also you can get to register.
Mm.
EFC code. So both way around that is possible. For the mainland code, this is the conditional factor to it.
Yeah. Okay. And what about the second part? Like, if UAE is having agreement with another country, and the one party belongs to another country, so they can run the case in that country instead of here.
So ideally, for jurisdictional factor, if the respondent is based in some other country, you can file the case over there.
And it will be then applicable here as well.
Not applicable here because you have a case against Mr. X.
Yeah.
That's based in US. Okay, he's permanently in US. You file the case against him here, then you will have to take it up all the way to US and then trying to execute over there. I'm not sure, by the way, whether there is a bilateral treaty with US. Mostly it should be the case. There should be a treaty. But I'm just giving it for an example.
Mhm.
The other end, if the respondent is based in some other jurisdiction or some other country, you can directly proceed to that country and file the case over there.
Okay.
There is a provision by law.
So I would like to know, like, what's your USP as a litigating lawyer in Dubai?
My USP as a litigating lawyer, I would say, is see, we are not people who just move people to litigate and dispute over, because if someone comes random and say that, I have a dispute and I think you need to help me, I just won't say that, okay, let me do it. Because two things I look up. One is whether he actually does have a case. Because if you look around, some might have even experiences where we have come across people who are just litigating because he's turnkeyed by his lawyer. We can very well see that.
Okay.
Which we don't do, because I'll tell you a very recent example that we had. One of my long-standing friend, they had to do a transaction with someone else in Achman, and it didn't go through well, and my client was being sued. Basically, my friend was being sued.
Okay.
It was merely an untenable, non-maintainable claim. It would have been negated any time of the day, which was very clear the moment we got the memorandum from them, because there is no merits to the case. More interestingly, there was one factor that the jurisdiction was mentioned as an arbitration center. Sorry, Oman Arbitration Center. Okay. The dispute is happening, actual dispute is happening in Achman. They gave the jurisdiction to Oman Arbitration Center. We took up the file. We said, okay, fine. And we are going to file the defense for that. And it was a very sizable claim. It was around for only 200,000. And we said that this one defense will do, that the jurisdiction is for Oman Arbitration Center. Thus, the mainland court doesn't have jurisdiction. That defense alone will do that the case against you will be dismissed.
Okay.
And we filed the defense. That was accepted by the court. And we were pretty much happy that, okay, it's done. And honestly speaking, we were never expecting that they will actually go to Oman Arbitration Center and fight over a dispute for 200,000. And they filed the dispute.
Okay.
They filed the dispute in arbitration. It makes way more expensive affair. At the end, it's technically some other country. Imagine both the party, that is the claimant who filed the case against my client, and my client, both of them are based in UAE. And the claim.
Then how come they chose Oman? Why?
So that was a case which shows that it was clearly a lawyer mooted case. I mean, because even if we go and contest that case also on the merits, it's definitive that he's going to lose it, because absolutely no merits to his claim. So we don't do that.
So what I understand from this is like it can be filed anywhere and it is even accepted. Even if you do not belong to that country, even if the case belongs to some other place, other nationality.
Arbitration, you can confer jurisdiction. You can give jurisdiction to any arbitration bodies across the globe. So it's like, say, for example, LCI or AAA, CR. These are all different arbitration bodies across the globe. These, if you are giving a return conferred jurisdiction, you can you can arbitrate on those bodies wherever you are placed.
That is also a challenge, means the person who's filing, if they decide to go outside the country.
That is a challenge. But the difference, what I'm saying here is that if he thinks on a financial perspective, or if he looks deep into the case, onto the merits of the case, ideally he should not recommend his client to go and fight a case, because it's arbitration, because it's a very nominal, it's not a substantial claim. And third thing, even if he gets an award from arbitration center, he will have to again come back here in UAE and execute it, which is going to be really time consuming too.
It seems to me as if that person, whosoever that party was doing, is doing it more out of ego and rage, probably just to annoy the other party, probably just to create difficulties. Because if financially it's not making any sense.
Maybe out of ego, as you rightly said, or maybe the lawyer voted him to do the case. I'm saying, if you ask me on my USP, on the second scenario, we don't moot unwantedly. I would say, like, it's a blanket answer. Like, if you have a case, you have a case. If you really don't have a case, you don't have a case. So I recently got an inquiry. My client invested with an entity, and it was for almost around 23 million Australian dollars. And he vanished within a year. And then it was realized that now he's happily living in Sydney.
Of course, with $23 million. Why not?
I mean, his company actually got that amount. His company actually got that amount of 23 million. So my client was like agitated, irritated, said that I want to sue him right now, I was like, yes, you can right now, no problem. But you have a big time problem. Then your company is here. It's a shell company. It doesn't
Okay.
any assets left. Like not even a proper office to be shown.
Okay.
Yeah. Rather it's a name board or it's a paper somewhere else, which he didn't do the due diligence. And he missed whole of the sum. And what happened? After the sum hit the company account, this guy siphoned it off entirely to his own use. He flew back to Australia. So ideally, the privity with that guy directly is not there. To do something else also, go fight it out in Australia better, not here. So I can be a briefing counsel. So I was briefing one of the Australian attorney back there.
Mm.
Up here doesn't make any sense. I mean, legally, yes, he has a case, but it's not about winning a case and getting a favorable judgment. Ultimately, you need the money back. So that is not going to happen for him if he contests the case and win the case over here.
True, true. It's good to be genuine, you are being honest. Whatever it is, you are giving good advices. So Abel, thank you so much. This session was very insightful. And I myself came to know a lot of things, and you have answered very generously and in detail about everything. So I hope this podcast, this information help our audiences. There are a lot of things you must have already learned from Abel. If you have more questions, you please write and we shall then see we can have another session with Abel on some other topics, important questions that you would like to know. Thank you so much. Have a great day. Bye bye.
Thank you, Ali. It was my pleasure.